Hi everyone, I'm Jasmin PACATANG from BSBA-FM. For today's lecture, we'll be discussing the general provisions and contract, that is Article 1305 to 1317. More particularly, we'll be discussing yung definition and contracts mismo, and try din natin i-distinguish yung contracts from the other terms such as obligation and agreements in general. And we will be also discussing the stages of contracts. Sama rin natin ang classification of contracts or yung kinds of contracts. And lastly, dito talaga magfo-focus yung discussion natin sa characteristics at mga contracts or yung mga basic principles. So, let's start! Article 1305. A contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So, obviously, Article 1305 provides for a legal definition and contracts and study meeting of minds, okay? Actually, it refers to two parties, so meaning pwedeng mas marami pa. Wala naman kasing meeting of minds na isang tao lang, right? So, kailan ba nagkakaroon ng meeting of minds? Kailan mo masasabing nagtagpo ng isipan ng dalawang parties? It takes place when an offer by one party is accepted by the other, di ba? Nagkasundo, nagkaroon ng agreement. Now, question. Kailangan ba na ang kontrata ay in writing? Kailangan ba may papel kung saan nandoon ang agreements o ang usapan ng both parties? The answer is no. Bakit? Look at the definition of contracts. It is the meeting of minds. So meaning, it is not necessary na nakasulat siya. Except lang doon sa mga contracts kung meron naman exceptions. May mga contracts na ni-require ng batas na dapat nakasulat. But generally, hindi kailangan na nakasulat siya para magkaroon ng kontrata. Kasi nga, by definition, it is the meeting of minds between two persons. Sa sandaling yung offer ng isang party ay tinanggap ng isang party without any qualifications, okay, so meaning nagkaroon na ng meeting of minds between the parties. At that time, meron ng kontrata, right? Save only for those instances na require talaga ng batas na dapat for a contract to be valid. Kailangan naka-in writing siya, like example is inside donation. Now, let's discuss also or let's distinguish contracts from obligation. Yung contract is actually one of the sources of obligations and yung obligation is mas broad. It is the legal tie or the relation that exists after a contract has been entered into. Now, if natatandaan nyo sa discussion natin sa sources of obligation, isa doon is contract. So, yun nga, meaning there can be no contract if there is no obligation. Kasi pag nag-enter ka into a contract, malamang may obligation yan at malamang pwedeng hindi lang isa, pwedeng dalawa, tatlo, depende kung ilang obligation ang mapapalob sa isang kontrata. But, in an obligation, pwedeng mag-exist si obligation without a contract. Example, kasi may mga obligations tayo which is nanggaling sa batas mismo, di ba? Yung ibang sources ng obligation. It could be by law and second doon is contract. Third is mga quasi-contract, quasi-demics, di ba? So, meaning there can be really be an obligation without a contract but there can be no contract na walang obligation. Kasi paano ka mag-enter ng contract na may laman? After nyan, magkaroon ng obligation, depende kung ano yung napag-usapan doon sa contract, okay? Now, let's distinguish contract from an agreement. Contracts are actually an agreement, pero ito is contract is enforceable to a legal proceedings. Kasi meron ding mga agreements which cannot be enforced by action in courts. Example, if ever nagkaroon kayo ng agreement with your friends to meet up and have fun, manood ng sine or what, kahit anong agreement, that is still an agreement. But, that is not a contract as defined by Article 1305, okay? An agreement is broader than a contract, so all contract are agreements but not all agreements are contract, okay? So, let's discuss naman itong stages in the life of a contract. Sabi, first stage daw ng life of a contract is yung preparation or conception. Ito yung preparatory step pa lang ang nangyayari which will lead us to the perfection of the contract. Kung baga, dito is yung bargaining point pa lang, okay? May nag-offer pero hindi pa nagkakasundo. Wala pang meeting of minds as to the subject matter and the cost or considerations. After a bargaining point, then nagkasundo na rin sa wakas. So, nagkaroon ng perfection ng contracts. Ito yung second stage ng life ng contracts. Dito na yung mayroon ng meeting of minds regarding the subject matter and the cost of the contract. Ito yung from the moment yung parties come to an agreement or come to agree on the terms of their contracts Okay? Now, yung third stage life ng contract is yung consummation. Ito na yung point kung saan papatapos na yung death ng contracts, di ba? So, the first stage is preparation or conception. Second is perfection, so perfect na. And the third is consummation. Ito nga yung time kung saan yung parties have to perform their respective obligations. And so, the contract is put to an end. Example, by December 1, si Cathy nag-offer siya kay Idil na ibebenta niya ang kanyang sasakyan for 1 million pesos. Tapos Idil nag-isip-isip pa. So, the following day, nung December 2, si Idil ay nag-counter offer. Sabi niya, bibilhin niya lang ang sasakyan ni Cathy for 800,000 pesos lang. Bibilhin niya daw ang sasakyan ni Cathy if ibibigay siya ni Cathy at a price of 800,000 pesos. Suppose, pumayag din kagad si Cathy. Malaki yung pangangailangan niya. Kailangan niya ng pera, so okay din daw. Ibebenta ko sa iyo ang sasakyan worth ng 800,000 pesos. So kinabukasan by December 3, ito na dineliver na ni Cathy ang kanyang sasakyan kay Idil. And at the same time, si Idil ay nagbayad ng 800,000 pesos to Cathy. So in this example, December 1 yun yung preparation stage or conception pa lang ng stage ng life of a contract. Dito nangyayari yung bargaining point or negotiation process nila. So, sa December 2, nagkaroon na ng perfection of contract. Dito, nagkaroon ng meeting of minds between Cathy and Idil. Now, nag-offer si Idil, diba, sa kanya galing yung offer na bibilhin niya ang sasakyan kung ibebenta ng 800,000 pesos. Pumayag si Cathy. So, dito nagkaroon ng meeting of minds as to the subject matter and the cost of the contract. And now, sa December 3, ito na yung consummation or death or termination ng contract. That is when Cathy delivered the car and Idil paid for the price or the 800,000 pesos. Doon na rin nagkaroon ng end as to the contract, okay? So, that is the stage in the life of a contract. Now, let's discuss yung kinds or classification naman ng contract. First, sa contract is classified according to perfection of formation. Sabi, pwede siyang consensual, which means pag perfected by mayor consent. Example niya is yung sale. Benenta mo yung sasakyan mo and pumayag, so that's a consent. Tapos, yung second naman is yung real contract, which is perfected by delivery. Okay, yung example dito is yung contract ng deposit and pledge. Kailangan i-deliver yung contract para ma-perfect yung contract. And third is yung formal or solemn contract. Ito naman yung nangangailangan ng special formalities para yung contract ay ma-perfect. Example nito is yung donation kasi na-require talaga siya na dapat balance. It must be in any public instruments para maging valid. Now, another classification in contract is according to cost or equivalent of value of prestations. Pwede siyang onerous, pwede siyang gratuitous, and pwede siyang remunerative. When we say onerous, then dapat meron siyang equivalent valuable considerations. Dapat meron siyang interchange. Onerous. Tapos gratuitous pag free. Yung isang party ay walang natanggap na or he will not be receive any equivalent prestations. Kasi nga for free. Gratuitous. Tapos yung third remunerative, ito naman is pag yung prestations is given for a benefit or service that has been rendered previously. So, remunerative. Tapos na yung service na rendered na previously. Another classification and contract is according to importance or dependence of one upon another. Pwede siyang principal pag stand-alone yung contract mismo. Sales, lease, yan yung principal ng contract. And second, pwede siyang accessory. An example dito is yung mortgage. Kailangan merong principal. Obligation, which is loan tapos i-attach doon sa mortgage. Si mortgage is an accessory contract. And pwede din pala siyang preparatory lang muna. Ito naman pag yung party hindi pa nila kinoconsider yung contract as an end by itself. Pero siya ay means na for future transactions or contracts na gagawin. Like yung agency or yung partnership. Now, pwede rin siyang maklasify according to the parties obligated. Pwede siyang unilateral at pwede rin siyang bilateral. Ang ibig sabihin ng unilateral contract is that there is only one of the parties ang may obligation. Example dito is yung comodatum. Yung for example, nanghiram ka ng bisikleta, so you have an obligation to return that bike afterward. Now, take note that although unilateral yung term sa kanya, it does not mean na walang consent o isa lang ang magigive ng consent. When you say unilateral contract, one part has an obligation lang pero yung giving of consent must still be bilateral. Dapat mutual pa rin yun. Do not be confused with the term. Now, another classification according to the parties obligated is yung bilateral contract. Yung both parties are required to render prestations. Yung dalawang parties or kung ilang parties man. Example is a sale. Yung isang party, yung seller has an obligation to deliver, tapos si buyer has an obligation to pay, so both has. Anyway, yung third classification is according to the name or designation. Yung contract would be nominate, ito yung mayroong particular name or designation na binigay yung batas. Like example is yung contract ng partnership, contract ng sales, contract ng agency or deposit. So yun yung na-identify ni batas at nabigyan niya ng pangalan. At merong mga rules, specifically rules na nag-govern sa kanila. Now, pwede rin namang si contract na inominate, meaning ito rin naman yung mga contracts kung saan hindi pa nabigyan or walang special main. We also have qualification according to subject matter. Pwede kasi yung contracts involves things like sale, tapos pwede rin involving rights or credits. Ito yung example dito, yung use of RAC or assignment of credits. Tapos, pwede rin yung subject matter is of the contracts involved services. Ito naman yung agency or yung contracts ng common carriage ganoon. Anyway, another classification is according to the number of persons who participated in the drafting of contracts. Ito talagang gusto ko siyang i-add sa discussion kasi I want to discuss on the contract adhesion. So, yung first is yung ordinary contract. Ito yung ordinary, yun nga lang kung like yung sale, both parties involved or participated in the drafting of the contracts. Lahat kayo may mga say. Tapos, meron tayong contract of adhesion. Itong contract of adhesion is repaired only by one person or one party. Ito yung usually the only participation ng the other party is to sign his name, his signature kung tatanggapin niya or hindi. Pwede niyang i-refuse. So, the better example for this is yung contract na kung napapansin nyo yung sa mga real estate company na draft na nila ng corporation. So, either mag-signify sila ng consent or hindi kung ayaw mo. Another is yung sa contract of insurance. Yung contract dyan, drafted na sila. So, yes or no ka na lang. Pero at least, you still have a say kasi pwede ka namang mag-refuse or to accept kung baga yung mga take it or leave it contract. Yan yung characteristics ng contracts ng adhesion. So, let's proceed. First, we have the autonomy of contracts under Article 1306. The contracting parties may establish such stipulations, clauses, terms, and conditions they may deem convenient, provided they are not contrary to law, morals, good customs, public order, or public policy. So, this provision talk about the freedom to stipulate. Marami mang tawag, iba-iba. Yung iba naman sa ibang libro, autonomy of will, principle of freedom, principle of autonomy of contract, pero sa discussion natin ngayon, we'll refer this as autonomy of contracts. So, the right to enter into contracts actually is one of the parties guaranteed by the Constitution. So, general rule yung parties are actually free to stipulate into anything. Sabi pa nga, we can establish such stipulation, clauses, terms, and conditions they deem convenient. Free tayong mag-stipulate ng kahit anong gusto nating maging kasunduan. However, naglagay din siya ng limitations that is provided na yung contract by legal. Sabi nga ni 1306, provided they are not contrary, unang-una to law, tapos morals, good customs, public order, and public policy. So, ito yung mga limitations at stipulations pang contrary, yun doon sa kanila. Hindi na rin naman pwede. Example is yung contract na vote buying, binibenta yung boto, so that is contrary to law and of course to public policy. Marami pang iba na contrary to limitations na hindi pwede, hindi valid. Yun yung mga limitations ng principle ng freedom or autonomy of the contracts. So now, let's proceed to Article 1307. So as discussed kanina, meron tayong contracts na may name or specific name or designation in law. Like yung sales, pledge, loan, or something. Yung mga yan. Yung law ng sales, yun yung mag-govern sa contracts of sales. Yung law naman of pledge, siya yung mag-govern sa law of pledge. Same with the loan, deposit, mortgage. But then, meron talagang contracts na inominate kung baga hindi pa napapangalanan or wala pang specific designation sa batas. Or ito yung mga inominate contracts. Yung mga contracts na walang specific name or designation sa batas. So, ang Article 1307 provides answer to that question.
Sabi, ang mag-govern daw sa mga innominate contracts ay number 1, yung stipulations ng parties mismo or either sinabi nila na this agreement be governed by ganito. The law or sales on something, nagpo-provide mismo sila kung ano yung nandoon, yun yung matutupad, yun yung law. Di ba nga, contracts are the law between the parties? Then, number 2, yung mga go-govern din sa kanila is yung provisions. Sabi daw ng titles 1 and 2 of this book, actually this refers to the law on obligation and contracts. Ito yung pinag-aaralan natin, so sa mga innominate contracts, mag-govern si obligation and contract. Then number 3, yung rules governing the most analogous nominate contracts. So kung ano daw yung batas if ever sa most analogous nominate contract, ano ba yung another term for analogous? Yung law ng most analogous, most similar, most identical, or kung ano yung closeness or congruent or pinakamalapit na klase ng kontrata. Yun yung law. Halimbawa, a contract na in-enter nyo is similar to that of sale. Then, the law of sale will also apply or will govern that contract. And last, yung customs of the place. Usually naman yung unique contract, yun yung mga usually, mga contract which are specific to that place. Kung baga, especially dito sa Pilipinas. So, when yung ibig sabihin ni Article 1307. Now, actually, there are 4 kinds of innominate contract. First is do ut des, meaning, I give that to you, may give. Number 2, do ut facias, meaning, I give that you may do. And number 3, facio ut des, means I do that you may give. And number 4, facio ut facias, I do that you may do. So, meron naman talagang innominate contracts kasi nga, hindi naman posible na anticipate lahat ng government at magawa nila ng specific law na go-govern to that particular contract. Article 1308. The contract must bind both contracting parties. Its validity or compliance cannot be left to the will of one of them. So we are now under principle of contracts, another characteristic ng contract which is commonly referred as principle of mutuality of contract. Actually, simply put into siya is both parties are bound, meaning the principle is based on equality of the parties. Contract should not just be left or should not just depend upon the sole will ng isang party. Yung both parties are of the same footing, yung dalawa or kung ilan man sila sa kontrata, hindi pwedeng isa lang ang nagde-decide after. That's your agreement na lahat ng parties are parties to that contract. Lahat may say, hindi pwedeng pag-ayaw na ng isa or kung baka according to his will or ano lang talaga biases. Remember, a contract is an agreement which will give rise to an obligation. Example, si Laika, she agreed to sell her cell phone to April for 5,000 pesos. Ganyan, so the contract is bind upon both contracting parties upon Laika and April. Kung nag-agree silang dalawa, ibibenta at bibilhin ang cellphone ni Laika worth 5,000 pesos. Now, if may stipulations doon na si Laika alone siya ang nagde-determine ng price ng cellphone, which will actually bind April rin, pero siya lang ang nagde-decide at walang choice si April. Hindi niya pwedeng tanggihan dahil ang option ay nasa kay Laika lang. So that violates the principle of mutuality of contracts. Kasi nga may quality of contracts, kung isipin mo kasi the contract is in meeting of minds between the parties, so there must be mutual consent na pwede mong isa lang. So dapat yung price kahit na si Laika ang magdedetermine, dapat i-accept na April according din sa price na okay sa kanya. So that's the time sale is perfected. Now, let's proceed to Article 1309. The determination of the performance may be left to a third person, whose decision shall not be binding until it has been made known to both contracting parties. So, ito naman yung exemption sa diniscuss natin kanina. Yung compliance ng contract should not be left to the will of one of the contracting parties only. Hindi pwedeng sa kanya lang, hindi pwedeng siya lang ang magde-decide. However, under Article 1309, determination of its performance may be left to a third person. Example, si Ritz binenta niya ang kanyang lupa kay Daphne. This time, nag-agree silang dalawa na ang magdedetermine ng price ng lupa would be Melaine. Kasi si Melaine pala is a real estate appraiser. So, siya ngayon ang magdedetermine ng reasonable price of the land. So, that is example of Article 1309. Let's proceed to Article 1310. The determination shall not be obligatory if it is evidently inequitable. In such case, the courts shall decide what is equitable under the circumstances. Anumang pagpapasya na ginawa ng third person ay dapat mag-bind ang both parties, maliban kung maliwanag na masama ito. Then the court will decide whatever is fair. For example, si Idil na nangungupahan sa isang rice field ni Lan ay hindi makakapagbibigay ng pag-upa or lease due to Lan para sa dalawang magkakasunod na rice season. So, who will be decide on the case? How do you think it will be decided? Justice or equity? Ayon sa Article 1310, ang korte lamang ang magde-decide based sa justice and equity. Justice means giving each what is due, but equity is a process by which court relax the sanctions of the law for humanitarian consideration. Article 1311 means that ang mga tagapagmana at tagapangalaga ay liable para sa isang kontrata na pinasok ng decedent dahil generally the rights and obligations are transmissible to them. What a person can receive by way of inheritance at sa makatawid bilang isang tagapagmana ay hindi maaring mababa sa kanyang pagiging lehitimo. Neither can be he obliged to pay more on an inherited obligation than the state he inherited. So, general rule, third person has no rights and obligations under a contract to which he is a stranger. For example, si April ay may utang na 50,000 pesos kay Cathy. If namatay si Cathy, ang kanyang anak na si Idil ay may obligasyong magbayad kay April but not beyond the value of the property or hindi lalampas sa halaga na pag-aari na minana niya mula kay Cathy.